I've watched investors lose everything because of the legal mistakes they didn't even know they were making. $500,000 in earnest money gone because they didn't understand their contract terms. Partnerships destroyed because there was no operating agreement in place. Investors sued personally because they didn't structure their entities correctly. And the worst part of it, most of the mistakes were completely avoidable. My name is Todd Robinson. I'm a real estate investment and finance attorney with my own law firm based in Atlanta, Georgia. But I'm not just an attorney who advises on deals. I'm an active investor. I have over $85 million of multifamily assets. That's over 750 units in my personal portfolio. Just last year, I closed over $40 million in new acquisitions. But here's what makes my perspective unique. Now, as an attorney, I've structured billion-dollar multifamily transactions for clients across the country. I've seen every deal from every angle, from every legal side. The contracts, the structures, the entities, the financing terms, the partnership agreements, you name it. And as an investor, I'm actively acquiring properties right now. I've negotiated with brokers, underwritten deals, raised capital, and closed transactions in today's market. That dual perspective, the attorney and the investor, means I see mistakes that destroy investors from both sides of the table that others do not see. In this video, I'm going to show you the biggest legal mistakes I see multifamily investors making every single day, why they're so costly, and how you can avoid them. Now, if you're serious about acquiring multifamily real estate and you don't want to lose hundreds of thousands of dollars on mistakes you didn't even know existed, watch this video all the way through. Let's get into it. So before we get into the specific mistakes, I need to address something that's been bothering me really for years. Most multifamily coaching that you see on the internet is taught by people that have done a few deals, 5, 10, even 15 years ago. And they've been selling courses ever since. They're not actively investing anymore. They're not closing deals in today's market. They don't know what's working right now. And here's the bigger problem. They're not attorneys. They can teach you how to analyze a deal. They can teach you how to raise capital, sure, but they can't teach you how to structure deals legally, how to protect yourself from liability, or how to navigate the legal complexities of real estate syndication and raising other capital raising structures, because they don't have that expertise. Now, I'm not saying they're bad people. I'm saying they're just teaching from an outdated experience and they're missing the legal side entirely. And they will honestly probably just refer you to another attorney when you start asking legal questions. Let me give you an example. I had a client come to me last year who'd been working with a multifamily coach. The coach taught him how to find deals, how to underwrite, how to raise capital, right? All the tactical stuff that you need. But when it came time to close his first deal, he had no idea how to structure the entities. He didn't know the difference between a 506B and a 506C offering. He didn't even have an operating agreement for his investors. He was about to raise $2 million from investors with no legal structure in place. Now, if he had moved forward without fixing that, he could have been personally liable for securities violations. We're talking potential SEC enforcement actions, investor lawsuits, and financial ruin. We fixed it. We set up the proper entities, we draft compliant offering documents, and structured the syndication correctly. But here's my point. His coach never taught him any of that. Now, because his coach wasn't an attorney, and that's the gap I'm filling, I'm not just teaching you how to find and analyze deals. I'm teaching you how to structure them legally so you'll blow up your life. All right, let's get into the specific mistakes. These are the legal errors I've seen multifamily investors make over and over and over again. They're costing people millions and millions of dollars. The first mistake is not setting up legal structures correctly. This is the most common mistake. And I'm not talking about just having a holding company. This is the most expensive mistake also. What I see is investors who buy property in their personal name. They get in trouble all the time. Or they use a single LLC for multiple properties. Or they don't set up a holding company structure. And when something goes wrong, a tenant sues, a lender forecloses, a partner has a dispute over ownership, they're personally exposed, right? So let me be clear. If you buy a multifamily property in your personal name and someone gets hurt on that property, they can sue you personally. They can go after your house, your car, your bank account, everything you own. That's insane, right? The correct structure is you need a holding company. This is your brand, your credibility vehicle. This is what people know you for. This is what you present to investors and brokers. And then you need deal-specific LLCs. Each property should be owned by its own LLC. That way, if something goes wrong with one property, it doesn't affect your other assets. This is basic asset protection stuff. But I've seen investors skip it all the time because they're trying to save a few $100 on legal fees, and then they lose everything. Mistake number 2, partnering without an operating agreement. I cannot tell you how many partnerships I've seen blow up because there was no operating agreement in place. Here's what happens. Two friends, they decide to buy a property together. They shake hands on it. And they agree verbally, yeah, we'll split it. We'll split the profits 50-50. We'll each put in 50%. We'll both manage them. Sounds great, right? Yeah. Until one partner wants to sell or has a life event that changes everything, and the other partner doesn't want to sell, or one partner isn't pulling their weight, the other partner wants to refinance, and the other one disagrees. How do they handle that? Now they're in a legal battle. And because there's no operating agreement, there's no clear process for resolving these disputes. I've seen these disputes cost $50,000, $100,000, even $200,000 in legal fees. And in some cases, they're forced to sell the property at a loss just to get out of the whole partnership, all because they didn't spend an extra $2,000 on an operating agreement up front. An operating agreement defines who owns what percentage, how decisions are made, how profits are distributed, what happens if someone wants to exit, and how disputes are resolved. It's the rule book for your partnership. And if you don't have one, you're gambling with your financial future. It's as simple as that. The third mistake is raising capital without proper security compliance. Now, this one scares me the most because it has the most severest consequences. When you raise money from investors for a multifamily deal, you're selling securities. This means you're subject to SEC regulations. Most investors don't know this. They think, I'm just asking my friends and family to invest with me. What's the big deal? Right? They're never going to sue me. Wrong. If you're raising money from multiple investors and you're promising them a rate of return, you are conducting a securities offering. And if you do it wrong, you can face SEC enforcement actions, investor lawsuits, even criminal charges in some instances. There are two main exemptions for what's called a private offering, right? This is not an IPO. You're not doing a public offering like Tesla, Uber, right? There's two main private offerings. One is 506B. You can raise capital from friends and family, people you have a pre-existing substantive relationship with. Unlimited amount of accredited investors, but you cannot advertise publicly. Now, in a 506C, you can publicly advertise, but you can only raise money from accredited investors, people who make $200,000 per year or have a net worth of $1 million or more. And you have to verify their accreditation. Most investors don't understand that difference. They post about their deals on social media, which, so you know, is public advertising, and they raise capital from non-accredited investors. This is a 506C violation, right? I've seen investors get cease and desist letters from the SEC. I've seen investors forced to return all the capital they've raised. I've seen investors sued by their own investor. This is not something you want to mess with. When you work with me as a real estate investment coach, I make sure your offering is structured correctly from day one. My law firm actually drafts the private placement memorandum for you, the subscription docs, and the operating agreements, all compliant with securities laws, because that's what we do, right? I'm an attorney and I know how to make this right. You work with a coach that doesn't know the securities implications of raising capital, you're going to make a big mistake. Now, the fourth mistake is not understanding loan terms. There's a difference between recourse and non-recourse. Here's the mistake, and this is a mistake that doesn't seem like a big deal until it destroys you. Investors sign loan documents without understanding the terms. What's the biggest issue? Recourse versus non-recourse. What's a recourse loan? A recourse loan is if you default, the lender can come after you personally. They can sue you, garnish your wages, seize your assets. A non-recourse loan is if you default, lender can really only go after the property itself. They can foreclose. They can't come after you personally though, unless there's some sort of what's called a bad boy carve out for fraud, negligence, things like that. Most community bank loans and bridge loans, those are recourse. Fannie Mae and Freddie Mac loans are typically non-recourse. I've seen investors sign recourse loans without even realizing it. Then the market shifts, the property underperforms, and they're personally on the hook for a $5 million loan. That is life altering. You need to understand your loan terms before you sign them. And if you're signing a recourse loan, you need to know exactly what you're risking. Mistake number 5, skipping due diligence to win the deal. This one kills me every time. I don't know who would waive due diligence, but investors get so excited about a deal that I've seen them waive inspection periods or waive the contingency or shorten that period to make it a more competitive offer. If you can't get your full due diligence done in 14 days, then don't offer 14 days. They end up closing on a property with $500,000 in deferred maintenance that they didn't even know about. They would have found out had they done their inspection period. I've seen it happen. Roofs need to be replaced. HVAC systems are shot, right? Plumbing issues throughout. $100,000 in environmental contamination charges. Suddenly, a deal that looked great on paper is a financial disaster. So never waive your due diligence period. Never. Never shorten your inspection period to win the deal. And if the seller won't give you adequate time to inspect the property, walk away. It is that easy. There's going to be other deals. Trust me. So why am I telling you all this? Why do you care? Because I am uniquely positioned to help you avoid those mistakes. I'm not just an attorney who advises on deals. I'm an active investor who's doing deals right now. Let me break down my portfolio for you. So I own over $85 million of multifamily assets. That's over 750 units across multiple properties. As of the recording of this in March of 2026, I've already closed on 80 units this year. I'm closing on another 140 units in March. And that 700 units is across multiple properties. Last year, I closed over $40 million in new acquisitions. Not 10 years ago, not 5 years ago, last year. I'm negotiating with brokers right now. I'm underwriting deals right now. I'm raising capital right now. I'm closing transactions for other investors right now. And at the same time, I'm structuring billion-dollar multifamily transactions for clients across the country as their counsel. That means I see the entire deal, both sides. As an investor, I know what it takes to find deals, analyze them, raise capital, and execute. And as an attorney, I know how to structure them legally, protect you from liability, ensure compliance. Now that combination is rare. In fact, I don't know anyone else in the multifamily space who has both of these attributes. And that's why my students are getting results. So when you work with me, you're not just learning theory, you're learning from someone who actively is doing deals and has the legal experience to make sure you don't screw it up. So here's why this matters for you. You're listening towards the end. I really appreciate it. This is where the rubber meets the road. If you're trying to acquire your first multifamily property, you're going to face legal complexity. Entity structures, security compliance, long-term partnership, loan terms, partnership agreements, due diligence. You can try to figure it out all yourself. You can hire it, or you can also hire a separate attorney that's never done a multifamily deal on their own. You can work with a coach who doesn't understand the legal side, sure. Or you can work with someone who's both an attorney and an active investor. Someone who's closed $85 million in deals and structured billions more for other clients. Someone who knows what works in today's market because they're doing it right now. Someone who can guide you through the entire process, from finding deals to structuring it legally to actually closing it successfully. That's what I offer inside Multifamily Deal Makers. Direct access to me, not a sales team, not a junior coach, me. I will introduce you to my broker network, my investors, my lender connections. I will review your deals with you. I will train you on how to underwrite, how to spot legal issues, how to walk away from deals, and how to structure your entities correctly. I'll make sure your offering documents are all compliant. I'll connect you with the right lenders, and I'll guarantee that you will close on your first property within 6 to 12 months if you follow the system exactly. And if you don't, I will keep working with you until we do. Because I have skin in the game. I'm not just teaching this, I'm living it. The legal mistakes I just walked you through, the entity structure, the partnership agreements, the security compliance issue, the loan terms, due diligence, these are all things that separate successful multifamily investors from the ones who lose everything. And here's the truth. You cannot afford to learn these lessons the hard way. The good news is, folks, you don't have to. Now, if you want the complete step-by-step system for acquiring your first multifamily property, including how to structure everything legally from day one, I created a full free course that walks you through the entire 90-day process. It's called the 90-Day Multifamily Acquisition System. And in it, I cover how to set up your legal structure correctly, so that it's going to protect you from day one, the exact underwriting process I've used to analyze deals, how to raise capital compliantly without violating securities laws, how to navigate financing terms and close your first deal. It's 45 minutes of pure content, everything I wish someone had taught me when I had started. You can watch it by clicking the video on your screen right now. It's completely free, and it'll give you the full roadmap to go from zero to closing your first apartment building. And if after watching that free course, you want my help in implementing the system, where I guide you through entity setup, introducing you to the brokers, networks, reviewing your deals, making sure everything is structured correctly, you can apply to work with me inside Multifamily Deal Makers. So start with the free course, click the video on the screen, watch it all the way through. I want you to take notes, and I'll see you there. Thanks for watching. Make sure you subscribe for more content on multifamily investing, deal structuring, and the like. I'll see you on the next video.